Good afternoon, everyone. I'm Nancy Hendrickson. I'm a past chair of the Securities Law Committee. I'm standing in today for Mike Margolis. We are fortunate today to have two excellent speakers who are going to be discussing recent trends in FINRA arbitration. I'll do you first because Andy's papers are on top, all right?
Thank you.
Okay, so to my immediate right is Bruce Lewittis. Bruce is a shareholder at Greenberg Traurig. He represents major broker-dealers, their officers, and employees in FINRA arbitrations, state and federal courts, and regulatory proceedings pursued by the SEC, FINRA, and various states. He has substantial experience representing clients in sales practice and employment-related litigation and arbitration proceedings. He has also served as a mediator on a number of occasions. Prior to joining Greenberg Traurig, Bruce served as executive director and unit head of Morgan Stanley's Midwest Litigation Office, ran his own small law practice, and was a senior attorney in the SEC Division of Enforcement. And next to Bruce is Andrew Stoltmann. And Andy?
Either or.
Okay. Is a Chicago-based securities attorney with Stoltmann Law Offices. He has filed over 1,000 FINRA arbitration claims in the last 16 years. He's currently the executive vice president of the Public Investor Arbitration Bar Association, commonly known as PIABA, and will become PIABA's president in October of 2017. PIABA is the International Bar Association of lawyers who represent investors in FINRA claims against brokers and brokerage firms. He was also the editor-in-chief of PIABA's Bar Journal for 5 years. Mr. Stoltmann is an adjunct securities law professor at Northwestern University School of Law, where he works with the Investor Protection Clinic. He appears regularly as a legal analyst for CNBC, CNN, Fox, and MSNBC. Gentlemen, I'll let you take it away.
Thank you. I'm Andrew Stoltmann. I've been doing this work for about 17 years, and I got to tell you, probably the last 12 to 18 months might be the most interesting time that I've seen in my practice during that period of time. And I'll tell you why in just a little bit. I've included some statistics in the package I handed out, and I'm not going to spend a lot of time on this. You can look through them yourself, but they're through November of 2016. They're updated stats, as updated as you can get, for FINRA arbitration claims. Not too much interesting stuff in here other than the fact that there's been a big drop in cases. There are 4,700 cases filed in 11, and now I think that number is down to about 3,200. And that's kind of to be expected with the market having gone straight up since March of 2009. But we are seeing some massive awards. We saw a $21 million rating claim against Robert Baird last week. We saw two $18 million UBS Puerto Rico cases in the last 6 weeks. So there are some very large awards coming out, but you can peruse through those stats. I also included in the package 2017 priorities letters, or a priority letter from Robert Cook. Robert Cook is the new head of FINRA, the president and CEO, and he's been kind of a blank slate. He hasn't given any interviews yet. We don't know much about his background. He was a partner at a law firm and worked with the SEC for about 3 years. So this is kind of the first glimpse we had into seeing what his priorities are for 2017. Couple of interesting things. The very first thing he lists are high-risk and recidivist brokers. There's been a lot of studies and coverage lately establishing that correlation between bad brokers congregating at one firm and the problems that happens with respect to customer protection issues. Cook has made it clear that this is something that he's going to target seriously, and it's some interesting reading, especially for those who defend broker-dealers, because the argument, gee, we didn't know that the broker with 27 complaints at the previous firm might defraud investors again, probably will ring a little more hollow with FINRA going forward than it has in previous years.
Well, that's an overbroad statement on how the street feels. The street's all for cleaning up high-risk brokers. I know ever since the heightened supervision guidance came out, all of the firms have been bolstering their review of brokers who come in with existing complaints, or if complaints happen while they're employed at the firm. But the firms are all for those smaller boiler room type shops being cleaned up. There's no question.
I will say that in my cases, Merrill and Morgan Stanley, which used to employ some of the worst, they do seem to have a less tolerant attitude towards hiring brokers with previous complaints on their record. We'll talk about the expungement issue in just a little bit. Just a couple other minor points that I wanted to emphasize. Number 2 on the priority list, senior investors, protecting them. That's always been a big issue for FINRA. Cook has reiterated that that's very important. Though the 2 areas that I found interesting were the excessive and short-term trading and long-term products, specifically variable annuities and UITs. Lawyers like Bruce, in a case where there's UIT or mutual fund trading, will say, gee, the turnover is only 1 or 2, and that's not excessive. FINRA is making clear that any sort of trading in long-term vehicles like UITs or variable annuities will be looked down upon. Cyber hacking.
I would only be forced to say that if we had to go to hearing. These are the types of cases that we like to make go away. I mean, it's an evolution of FAs figuring out ways to game the system. As these products as these newer products come out and they become more familiar with them, they sort of figure out how to make it work and stay off the radar screen. And it's like an arms race with the firms trying to surveil for it.
Finally, Cook made clear, FINRA President Robert Cook, social media and cyber security are 2 areas of emphasis. And this is interesting because up until about 3 years ago, I'd never had, in effect, a hacking or cyber hacking claim. Now, in the last 2 years or so, I've had about 5. And by that, I mean unauthorized folks logging into people's brokerage account and absconding with money. So it's really interesting. I think it's an area of emphasis for FINRA going forward.
The firms.
They're not identity theft, but they're unauthorized people taking money out of the brokerage accounts. And FINRA is crystal clear. If there's a change of beneficial ownership, if I take money out of my brokerage account and it goes to me, no problems with that. But these are situations where money leaves, let's say, my brokerage account and goes to John Smith. And that change of beneficial ownership of that money triggers responsibilities per FINRA. And we've had cases where unauthorized folks have taken that money, stolen it, and we've sued the brokerage firm to get it back. Mr. Glick?
Those would be criminal offenses.
They'd be criminal offenses against the person who did it, but of course that person never has, it's hard to collect from those folks.
And you work with FBI or some police agency?
We certainly will, but 9 times out of 10, it's a situation where that person doesn't have the money, so we can rope in the brokerage firm for not following up on that change of.
The criminal thing just goes up by itself.
It does,
and the firms write checks for those.
They do,
because I think that's governed by like the UCC or something along those lines, where as long as you alert the firm by a certain time period, it's strict liability.
According to Bruce, it's within 3 minutes of your client finding out. All right, I want to talk about a couple of. Bruce, was there anything else you wanted to say on the priorities list?
All good.
Okay. There are a handful of issues that PIABA, the plaintiffs' bar group of lawyers who sue banks and brokerage firms, are pursuing in the last couple of years. Probably the biggest hot-button issue right now, for lack of a better word, is getting established an unpaid arbitration pot for investors who sue their brokerage firm, get an award, and don't collect. And it's an interesting case. There was a gentleman by the name of Willie Cabill, who the lawyer who handled the case on the other side is here. We won an award. We got stiffed, and you may say, well, that happens, but it's much, much, much more prevalent at FINRA than most people think. It's a massive problem. The GAO in 2003 calculated 64% of all FINRA arbitration awards go unpaid in any given year. PIABA did its own study on numbers in 2014. The numbers were they literally examined every single award to see if the money was collected. According to PIABA's report, one out of three awards goes unpaid. 1 out of every $4 awarded to claimants goes unpaid.
Now, is that sales practice, or is that sales practice and employment?
It is just customer cases against brokerage firms. $62 million of money went unpaid in, again, it's either 13 or 14. FINRA's current position is, well, gee, we bar the brokers and we tell customers they can go to court to collect it, which is, meaningless. What's interesting, after Piaba's report came out, Elizabeth Warren called then FINRA CEO Rick Ketchum to testify. And on record, he said this is a serious problem and FINRA is seriously looking at solutions to it. It could be just lip service, but usually people just don't give lip service to Elizabeth Warren. I think FINRA is seriously looking at this issue. Piaba proposed an unpaid arbitration pot funded by the securities industry a couple different ways, one of which is a $100 fee a year on the 600,000 brokers out there that would create that $60+ million pot, or that FINRA pays into the pot, an unpaid arbitration pot. And the numbers we cited were, the net income for FINRA in 2014 was $129 million, and they refunded $20 million to member brokerage firms. So, I have a feeling in the next 2 years you're going to see this unpaid arbitration pot established, and I think it'll be revolutionary for investors. Mr. Glick?
I'm pretty sure. In fact, I actually, many years ago, general counsel of a company, collected money from something like that in the insurance industry, where an insurance company had failed. There was an insolvency, which happens not that infrequently, and there was a large claim. And I was able to collect something like 80% of it from this Illinois. Now, Illinois is so screwed up, who knows if it even exists anymore.
Right.
At least there's that precedent for it.
Yeah.
Can I ask a question? We all know that CIPIC is there to protect investors in certain kinds of cases, but not unpaid award cases. But what about modifying that?
The question for people watching online was, what about CIPIC? CIPIC over the last 30 years has paid out, I think it's less than 1% of what they've collected. CIPIC is kind of like the Venus flytrap. It takes money in and it doesn't pay it out. Getting it expanded would take congressional approval, which is simply obviously impossible to do in the next couple of years. This is a problem that FINRA can rectify. I think they're going to rectify it, and I just don't think CIPIC is the right solution. The insurance was looked at too. In Illinois, you drive a car, you have to have insurance. So common sense would say, hey, shouldn't these brokers have insurance? The insurance companies are really good at adjudicating and determining risk, and they won't insure these brokers, or if they do, the deductibles are so massive that it makes it impossible for these guys to afford it. And they also carve out most of the chicanery that brokers get into. Ticks, illiquid investments, variable annuities, all this stuff. So the insurance option was looked at. I just don't think it makes sense. We think the arbitration pot makes the most sense. I think Bruce has some strong views on this.
Well, I'm agnostic as to whether that type of pool should exist. I'm not agnostic as to how it's funded. I'm not sure it's the most equitable solution in the world to have the firms that are already paying their awards fund the firms that aren't paying their awards.
I think what Bruce might be leaving out of the equation, though, is this. We had a series of cases, probably about 30 or 40 cases, involving a private placement called MedCap, Medical Capital. And Ameriprise, which at the time was the 5th largest BD in the country, in court, their CFO testified that if this limited fund settlement wasn't approved by the court, and it was 5 cents on the dollar, 7 cents on the dollar, Ameriprise was going to close up its shop. And that was the 5th largest firm in the country. You had Lehman Brothers, a top 10 firm, go out of business. And you had Morgan Stanley, who, but for a $10 billion taxpayer-infused bailout in 2008, would have gone BK, and there would have been hundreds of millions of dollars of claims against them. So I understand the big firms are the biggest opponent of this plan. And understandably, they're saying, why should we pay when we pay our awards? But they don't always pay their awards.
So,
Yes, Tanya?
Follow up. Assume for the sake of argument firms who do pay awards were asked, look, we're going to do this somehow. Somehow we're going to find a pot. We're going to create a pot. We understand that you're neutral about whether we should or not, but we made the decision to create a pot. Now we're asking you, the firms that are good about paying awards for the most part. Again, Andrew, you obviously have a right to disagree with that, but from your own description, you are the firms that pay awards. So we're telling you we decided we're going to have to fund this somehow. What would be the least unpalatable thing from your client's perspective, the perspective of well-known, well-recognized firms who generally are viewed as paying awards, good citizens, at least from the standpoint of some people?
Wow, putting me on the spot, Les. I haven't given it enough thought, but I do like your intimation earlier to the effect that maybe this could be rolled into what SIPC's charges.
Tanya?
So maybe there's a middle ground there, because it is true that there are some larger firms, for example, Dave Lehman and I know about Ameriprise, who might be subject to not being able to pay. It seems to me that this is largely product driven. If you're going to sell private placements, and that's what we saw with MedCap and many other firms that go out of business, is because they're selling private placements and they haven't either done their due diligence or something happens with the issuer. If you're a large firm, whether you're Merrill Morgan or a small firm, and you're going to engage in private placement MedCap type sales, maybe you should contribute more to the pot.
Like a tax per transaction?
Well, depending on the product you sell, because some products really are more prone to, when they fail, there's a huge payout that's going to come.
Right, but you see, for example, Puerto Rican bonds, UBS isn't defaulting on those. They're arbitrating them and paying the awards, except the unusual one that they move to vacate. But once they lose that motion to vacate, they're paying that award.
But Bruce, those are UBS proprietary funds that own Puerto Rican bonds. So, yes, they're paying. Tanya, we also looked at the idea of increasing the net capital requirements of these brokerage firms. But that proved to be untenable because most of these firms simply couldn't have that form of that much money still on their books. And so it's a thorny problem. I mean, look, if you're selling those alternative investments, I would agree with you. That's where most of the problems do accrue. And so, again, I'm sensitive to the needs of the big firms, but it really is, it's an industry issue, not just a small firm issue.
And with all...
What's that?
Maybe the investors pay. Everybody pays, when you go through the airport security, everybody's paying for security. Maybe the investors kick in some money.
Yeah, or Alan suggested the investors chip in the money, but it's a brokerage firm problem. So you know what?
It's your problem.
Well, Alan, if a firm can't afford to pay a $500,000 arbitration award, guess what? You shouldn't be out there. And I'm sorry, but if I'm driving in Illinois, I have to have insurance. I have to have insurance, as in most states. And you guys, the brokerage firms, aren't required to have insurance. And if you're not going to force these firms to have insurance, you guys, in my opinion, should have to pay to create this pot to solve this long-term problem.
Some giving investors a put?
No, you're not giving a put because you still have to go through the FINRA arbitration process. You still have to prove your case. You have to prevail in front of 3 arbitrators like Mr. Glick here, and prevail and win and meet your burden of proof. And if you do that and the firm closes up, then you can go to the pot and try to collect from it.
Something to just throw out there for us to mull over. We don't need a debate. Maybe it's too easy for these firms to become licensed broker dealers.
Bruce, I agree with you. And I'll tell you right now, in my opinion, if a pot is established and if Merrill and Morgan Stanley and other brokers have to pay for it, the big firms will exert enough pressure on FINRA, a self-regulatory organization, to keep these small shops out, to make it harder for them to operate or harder for them to step up. I think FINRA would be receptive to the push of big firms to tighten the requirements if they have to pay this problem.
That sounds good on paper, but it's really fiction. If the firms can't put the kibosh on this pool, what are they going to do to exert pressure on the brokers later on, or to exert pressure on FINRA later on to have their competitors not get licensed?
Right. I mean, in theory, you could actually make the problem worse just because these firms now know that they're not ultimately going to be responsible because
why not just be even more reckless than they have been in the past?
And what's interesting is, I mean, I probably turn down one case a week because of collectability concerns. There's $62 million on unpaid arbitration awards 2 years ago. If you take into consideration the cases we don't take, chances are it's a much bigger problem than $62 million. If you're filing those cases, where you weren't certain about collectability, getting an award, the problem would be even bigger. So look, it's a thorny, difficult issue, but this problem has been around for so long, it needs to be rectified.
By the way, the problem also impacts the firms. We have probably 3 times that $62 million number in uncollected promissory note obligations, and it's super easy for FAs to establish their inability to pay.
Well, maybe you shouldn't be giving these $2 million forgivable loans to these guys who can't manage their own money, much less clients' money.
Yeah, I'm not going to argue with that.
First, the bona fide inability to pay is no longer a defense to promissory note cases. So if they don't pay, then they're going to be subject to a non-summary revocation of their license.
Right? No, they can establish inability to pay to FINRA, and not lose their license.
Yeah, I'm dealing with that right now. I'm trying to collect from a broker.
And the firms aren't allowed to participate.
In the arbitration.
No, once there's an unpaid award, a FA can plead poverty, and it's almost a rubber stamp. And the firms, trust me, I've done 5,000 of these. The firm's not even permitted to appear. They can't even. They have no say. Not that I expect anyone to cry any tears for the firms, but there are, this drips down to local management, right, and their compensation, right. If $2 million or $4 million hits a local branch manager's P&L, it's real for them.
Professor Google tells me that the Illinois Insurance Guarantee Fund is very much alive and functioning. I'm not sure I've been trying to find out how it's funded. You've got to read 10 pages to figure it out. There is such a thing, and that might be a good model to think about with respect to a brokerage guarantee fund.
Yeah, I am all for an equitable solution so that the people on Main Street who get bilked by brokers aren't without recourse. There's no question that I'm for that, and I'm sure any reasonable person would be.
Indiana has a pool set up, but part of the problem is it's limited to about $10,000, and it's not a very big pool per claim. It's either per claim or per person, but it's relatively de minimis, and the effort in getting it implemented at the state level in 50 different states is so difficult. Piava took the position it'd be better to have a national solution than a state by state. I want to move on to another hot button issue at FINRA that's been very important to Piava. It's the expungement problem. And there's been a lot of coverage on this. And for those of you who aren't familiar with it, an investor will file a claim, the investor will settle, and the claim ends up getting expunged as part of the settlement with the brokerage firm. Some unsuspecting investor goes to the CRD, looks at his or her broker's CRD record, and they see it's completely clean. They say, wow, my broker's a great guy, but they may not be aware that there have been 3, 5, 10, 20 claims that have been expunged. Piava's study between 12 to 14 found that 90% of the expungement requests are granted to the person who is asking for them, and it kind of places the claimant's lawyer in a little bit of an ethical conundrum, because you obviously have to do what's best for your client, and if what's best for your client is agreeing to agree to this expungement in part to get this settlement, 98 out of 100 claimants will say, okay.
You can't agree to an expungement in a settlement agreement.
I understand that brokerage firms aren't allowed to make it contingent on the settlement. The de facto reality is that it happens all the time. And so kind of the issue is FINRA has come out and said expungement needs to be an extraordinary remedy. Mr. Glick, you're an arbitrator on hundreds of cases. I'd like to see if you have any insight on this issue.
Well, I've had very odd case, but I have had a number of the expungement issues, and in every case, I found, and my co-panelists agreed, that the broker really was not at fault. So of the many cases I've handled and have pending, I haven't seen any where it was really absurd to ask for the expungement. So of, let's say, 100 cases, maybe 5 or 6 have actually had the expungement request. So the ones that really have the dirty hands have not, at least in my experience, have not requested expungement. I mean, we look very, very hard at what actually happened, and sometimes you'll find against the broker, very often not. Actually, when we found against the broker, nobody has ever asked for an expungement. I mean, it's a contradiction in terms to do so, almost. Although I guess some odd situation might exist.
A product case of some sort.
Yeah, something like that, yeah. So the ones that I've had, and I'm familiar with, the broker was, the award was in favor of the broker, not in favor of the claimant. And so that doesn't necessarily exonerate the broker, but it certainly helps that he was not found to have done anything wrong. But so my experience has been, I think, logically consistent with the way it's supposed to work.
What about settled cases? When the cases are settled, you never hear it.
Yeah, well, no. There have been several settled cases where expungement was requested, and as I recollect, it's hard. There might have been like an even split. Honestly, God, I don't remember.
Yeah, unless they do have to go before a panel and have them heard and settled.
The same process.
The panel has to hear the case on expungement even if you settle.
Yeah.
And the panel never hears the underlying case.
But I think part of the problem is they tend not to hear from the claimant who doesn't show up because they've been paid. So you're kind of hearing one side of the story. Tanya, I'd be curious. Joe Borg, Alabama Securities Commissioner, has proposed that the expungement be taken out of the hands of FINRA and given to the state securities regulators. You guys are so busy. I'd be shocked if that's something you could handle. I'm just curious. Maybe you can't comment on that, but is that something you have heard? Is that something you might be interested in?
2 seconds per case for them to say no, right?
For me personally, I want to speak for Joe Borg. I think it has been, Joe may have said that. I think I've heard it also, and it may even have been something that was part of the Arbitration Task Force report that was issued a year and a half ago, where they made certain recommendations. I read a lot of expungements that I would not have granted, and I think this is the problem. The purpose of expungement is to expunge a case where the wrong broker was named or the allegation is totally false, like none of this ever happened. The fact that the broker, that the arbitration panel found that the investment was suitable versus not suitable, or that a disclosure was made versus not made, is not a grounds for expungement. And what I see all the time is arbitrators saying, well, we found that this particular variable annuity was suitable, therefore we're going to grant expungement. That's not a grounds for expungement. If you file in the Circuit Court of Cook County, if you win, the whole case doesn't get expunged. It stays there, and people can read and say they won. Same thing here. You could read and say this broker was sued and he won.
That's a function of the FINRA's own rule, though. If they find that the investment was suitable, that means in turn that the allegation that it was unsuitable was false.
I don't think so, Bruce.
That's not the intent of the rule, and FINRA will tell you.
But that is how it's written. But in any event, it's a two-edged sword, and most cases, there's 2 sides to the story, and most cases are somewhere in the middle, right? On the one hand, you don't want brokers who've engaged in wrongdoing to have clean records. On the other hand, you don't want brokers with an otherwise spotless record whose client has sued them simply sour grapes because of losses when nothing was in essence done wrong, to have their records marked up. I mean, that's not.
From what's happening in circuit court, you sue a doctor.
There's no CRD for doctors.
It's all public.
Well,
Right, but we're not. We're
Mr.
not.
Glick?
Yeah, let me chime in a little. The way FINRA has explained the rule, and the way I know the panels I've been on have viewed the rule, rightly or wrongly, and whether or not consistently with your experience, we really don't. I mean, I've had industry panelists talk to me about the terribly devastating effect something on a CRD can be to someone. And the intention, as I understand it, and I know every panel I've been on where we've had to deal with it has understood it, if the guy or lady is just innocent, the case stays on the record, but it's expunged from the individual's the individual CRD, so that when you look at broker check, you don't see this glaring thing where somebody would say, "Oh my God, I'm not going to deal with that guy or that woman because look how they screwed somebody." The intention really is to clear that up, and we do take a hard look. Not everyone gets expunged just because the ruling is the award is in favor of the respondent. Sometimes there's kind of a narrow ground, and the award can be in favor of the respondent, but yet the broker wasn't lily white or that pure in the handling of things. So it's a case by case thing. But to simply say it was filed, therefore it must stay on, would make the expungement rule meaningless. Nobody would ever get expunged.
Howard?
So I'm kind of fixated on the 90% request granted rate.
That's 2012 to 2014. So those stats are getting stale.
Right. And those stats went into effect or cover a time period after the new rule to tighten up expungement requirements went into effect. Right? That was.
Yes, I don't know what the latest standard is, what the latest percentage is, but just from my anecdotal experience, it's still pretty high.
That was before FINRA called it extraordinary remedy.
Yeah.
And that,
I would say with that numbers in most cases are settling, you're getting expungements in settled cases where there's not an adjudication
Right.
in favor of the respondents.
Right.
But that really there's a blank slate in front of the panel other than just seeing these things that claim response.
Right.
And the settlement agreement.
Right. Which
We see that too.
Yeah.
which is not going to provide very much color for a panel.
But what I've had to do over the last year is actually go before panels and give them a binder of exhibits establishing my point of view. And sometimes they are contested. I had one in Jacksonville 6 months ago that was contested.
but have you ever had one denied where expungement wasn't granted?
I've gotten plenty of zeros where expungement was denied. And for settlements, I'm very selective about the ones I ask for expungement.
So, no, you've never had
Yeah,
one.
I have. And
Okay.
hearings where I've gotten zero, my expungement requests have been denied more than they've been granted.
Yes, Tanya,
Well, I say
please.
when I see these granted often, they'll say the broker has a clean record. That's because there were numerous other previous expungements.
Maybe.
Yeah, I've seen it.
No, that's true on occasion, but generally speaking, brokers aren't getting numerous expungements. At least the ones that I deal with. I'm sure in the smaller firms they are. But yeah, over the year, I'm sure most of them predate FINRA tightening up this area.
Les?
I'd like to ask both of you a question on this. perspective, it's a horrible thing, and it happens all the time, and it's gaming the system, and it's horrible, and if you settle, you can assume that you'll never, ever have anything but an expungement. And from the defense perspective, it's you're besmirching a broker. He had a clean CRD before, now you're trying to take one case or two cases. And the tough decision about how do you grapple with the middle issue from a defense or a plaintiff's perspective has not really been addressed. It seems to me that from a plaintiff's perspective, a Piaba perspective, Bruce, you would have to say, well, if I were not a defense lawyer and I knew that there were 7 expungements, okay, on one broker, that would, at least from a regulatory perspective, be something that at least a regulator might want to look at. Maybe I am still, as a defense lawyer, trying to do the same thing for this broker as I would do for any broker that I was paid for, but it's something that a regulator might want to know.
I would, now that you mention it, looking at it objectively, the information under the new 2017 rule that has to be provided to arbitrators as part of the motion for the expungement, I would have no problem with it including that information. And I think it would be important information.
I think that's a major point that Bruce is conceding, as in fairness and in great respect to you, Bruce, that you would say that. And I think that's, now I got to put the spotlight on you, Andrew. If Bruce agreed to that or the defense or the Morgan Stanleys and Merrill Lynch's of the world, would say, okay, look, if it's over 5 or 7 or whatever the magic number is, then that has to go to the panel before they grant expungement, something I bet you'd like to know. How would you feel? What would make you say, no, wait, this is outrageous, this is unfair? Speak as a plaintiff's lawyer, as a Piaba guy, president to be.
Well, I mean, I think my position is pretty clear in that if there's a customer complaint that's been filed and a brokerage firm pays out $25,000, $50,000, $75,000, that needs to be on the broker's record. And a customer can make a determination if it's a $2 million claim and the firm pays out $25,000. The customer can make his or her decision and say, wow, that's pretty frivolous to me, but I think it needs to be on there. And if it's a scarlet letter, then so be it. I think customers are pretty sophisticated nowadays that if they see 7 or 10 complaints on the record and there's a total of only $100,000 paid out on $30 million worth of claims, they can make that judgment. I just think you're hiding stuff from customers. I think it's an artificial process, and I think investors get left holding the bag.
When would you say that an expungement is appropriate?
If in the 3 very narrow circumstances that FINRA delineates, if a broker is mistakenly named, if help me out, Alan, if it's a situation where the claim has already been adjudicated, factually impossible,
Demonstrably false.
Well, it's usually there's only one that is really
Sure.
demonstrably false.
Yeah.
And then that rides right next to award in favor of the respondent. How would you distinguish the case where a broker where the award is in favor of the broker personally and his firm, and at the same time denying the it does happen, but I'm interested in
that has to be on the on the CRD. It doesn't mean that the claim was false. It doesn't mean that claim didn't have any merit. It just means they didn't meet their 51% burden of proof. And so we've all had cases, strong cases, that for whatever reason the arbitrators didn't agree with it. Doesn't mean it was frivolous. Doesn't mean it wasn't meritorious. It just means they couldn't meet that relatively high burden of proof.
We're also, and I'm sure you're a great arbitrator, but there, well, you're at
But
but I've also
Shouldn't say that,
seen
you
written descriptions where I think the arbitrators, not attorneys, not saying that they have to be, but just completely misconstrue the law. And I know you've seen this. I'm probably going on both sides. And so, with no review really that occurs, we take it for granted that the arbitrators,
firms do hire people with awards. Even the bigger firms, they've loosened that up quite a bit, which goes back to the recidivist brokers discussion earlier. Look, the FINRA arbitration process is always a little wobbly as far as equity goes, and just like with the awards, it's the same with the expungement. And for better or worse, this is the system that we're stuck with.
A couple other issues, and Tanya, that's actually a good segue. The broker check, big issue for Piaba in the last couple of years. And the biggest issue is there's a discrepancy between what FINRA releases to the public and what the states release to the public. They're not the same. And FINRA spends, it's tough to say exactly how much, but it looks like at least $10 million a year on advertising. Check your broker's background on the FINRA website. And there's a substantial discrepancy between what FINRA has and what the states has. Piaba has called very aggressively for those two databases, even though it's technically the same database. It's just what's released on the FINRA system is not the same as what's released on the state system.
You're talking about the public broker check.
That's right.
FINRA has the full CRDs.
Well, and Piaba has called for both to be harmonized, what the states release and what FINRA releases, raising it up. For example, FINRA's not required, I shouldn't say not required. FINRA doesn't release the following information that states do. Number one, internal reviews by a former employer. Now, I represent to you, if I'm an investor, I want to know if my broker's former employer was investigating something related to his or her behavior while at the firm.
No, that's only if you're being investigated at the time of termination and you resign.
Well, Bruce,
there's no disclosure strictly for internal reviews.
Well, I'm taking this directly from FINRA's website, and one of the things they say is when a broker is the subject of an internal review by a former employer, disclosure information regarding that matter is not provided on broker check.
It's not provided on the CRD. If a broker is investigated for using discretion and they remain employed at the firm at the time it's concluded that there was no responsibility, or we're going to give you a letter of reprimand, that's never disclosed.
I disagree. I believe the states disclose that. Number two, scores.
Are you saying the states don't disclose?
States
I'm saying no one discloses that.
No one, including
Right.
states.
The yes answer on the Form U5, and this isn't on the Form U4. The yes answer on the Form U5 is, was the advisor being investigated internally at the time of termination?
Well, what isn't on there's reasons for termination that are not related to customer issues or violations of the securities laws. So if a broker is investigated for something, say sexual harassment, something at the firm that isn't customer related, that will not be on FINRA's disclosure. It will be on the state's disclosure. We think that should be on both of the disclosures. Number three, judgment or liens that have been satisfied are not on FINRA's disclosure, but are on the state's disclosure. We think that's important. If you have a tax lien, even if you satisfied it, I want to know it. I mean, if you can't manage your own money, if you can't manage your own taxes, and you're a broker and you want to manage my money, even if you go back and eventually pay for that, I want to know that. And finally, scores for brokers on failed examinations are not on FINRA's site, but are on the states. We think that these have to be harmonized, that investors get the same thing on state CRDs as they do on FINRA's.
Well, for the record, any investor can go to the state and request a CRD.
But
having said that, look, this was a negotiation between you guys and the street on what should be publicly available. And Ms. Solov, this is a distinction between our industry and the medical industry. Everyone can just type a few keys on their laptop and get a broker's record. It takes more of an effort to get a doctor's public record from the court system. I mean, it's so easy in our industry. And
Well, it's getting easier for the medical profession. You can type in some doctors and get, various lawsuits and things like that.
Right. But through Google, right? There's no centralized location like the CRD. The point is, this was negotiated between taking into account both sides' interests.
Okay.
And, talk to your congressman. Just kidding.
Couple other areas because we're running out of time. The improvement of the arbitrator pool at FINRA, diversification of the arbitrator pool. Now, I'm all in favor of old white guys, and I hope to one day be one. But the pool has to be the pool has to be expanded because I've long taken the position that he who controls who the arbitrators are controls everything. All of the rules, all of the modifications of the rules won't make a hill of beans difference if you don't have an expanded, diversified arbitrator pool. FINRA agrees. They've said, quote, the diversity of the arbitrator pool must be increased. And the $64,000 question, Tanya, you referenced the task force, the arbitration task force. They couldn't reach agreement on this issue. And the broad issue is, should arbitrators look more like judges or should they look more like jurors? And FINRA takes the position, gee, these cases are really complex. The average guy off the street, Joe Plumber is the term that we use a lot. Joe Plumber can't understand this stuff. So we have to have people who are more sophisticated. Industry guys.
Oh, no, we don't want that.
Well, hey, Alan, I'll tell you, in some cases, I love the industry guys. There are very clearly some cases, but...
Can I make an observation?
Sure, absolutely, Mr. Glick.
In my cases that I've done, invariably, the industry guys are tougher on the respondent.
And there are, in my selling away cases, I want an industry guy. On my theft cases, I want an industry guy. Where I don't want an industry guy, and I won't name the firm, but it's a national wirehouse in the Schaumburg location. I had a case for a retired factory worker who was recommended a variable annuity in his IRA, and he lost money. I took the position that that was unsuitable. There are all these regulations out there that say, you don't put a tax-qualified investment in a tax-qualified account like an IRA.
There's no outright prohibition.
No, but they're warnings from FINRA, Notice of Members.
It doesn't make sense.
I was
They have a lot of features.
I was preaching to one of the three arbitrators on the case who managed a wirehouse branch office that I knew with absolute certainty those guys were frequently recommending variable annuities in their IRAs. And guess what? We got a 15 cent on the dollar award, and I thought that was fundamentally unfair. FINRA right now takes a position, gee, these issues are too complex. You have blue-collar Joe the Plumbers deciding antitrust cases, deciding capital murder, death penalty cases. I think a Joe the Plumber can figure out if an account was churned or investment was unsuitable. FINRA requires 2 years of college credits or 5 years of business or professional experience.
Not a high bar, Andrew.
Bruce, guess what it is? Because the average guy who didn't graduate from high school or just graduated from high school and works as a plumber is precluded by FINRA's rules. A military veteran who served his country, has a high school education, doesn't have the business or professional experience.
Well, that's ridiculous.
It is ridiculous. So I guess our position is expand that pool. For those of you who are arbitrators, how many arbitrators are here? Besides, okay, if you filled out that application, that thing takes forever. It takes FINRA a long time to approve it. They have to streamline that application and loosen the standards for who can be a FINRA arbitrator.
Or market better. Because there's plenty of diversity with people who meet these minimal requirements.
That's what FINRA says is, gee, we market heavily, but it's been our experience that FINRA is marketing to bar associations. FINRA is marketing to CPA organizations. And guess what? There's some wonderful CPA arbitrators out there. There's some wonderful lawyer arbitrators out there. We think if you're going to force people into arbitration, right, they have no choice, that you got to get a pool that's diverse, that has all segments of society, and not just accountants, not just mediators, not just attorneys. And again, that's not a dispersion on any arbitrators out there. It's just the reality is the pool has to be expanded. Piava's report concluded the average age of arbitrators is 69 years old. 40% of the arbitrator pool is 70 or older, and 17% of the pool is over 80. And again, that doesn't mean anything in and of itself. It doesn't mean anything.
80 is the new 70.
But our position is you got to expand the pool. You got to get a broader, more diverse group of arbitrators out there.
Let's get to that last topic. That's the best one.
Which one?
Claimants should have their choice whether to go to court or arbitration.
PIABA's position for the last 25 years has been investor choice, right? If FINRA is the end-all, be-all, wonderful, fantastic, fair forum that adjudicates claims fairly for everybody, then don't make arbitration mandatory.
Well,
Hold on, just let me finish. Let investors have a choice. It's been PIABA's position for over 20 plus years. Keith Ellison, House member from Minnesota, has proposed the Investor Choice Act that would allow customers in any case where they have a binding arbitration put in by your clients.
Signed by yours.
Well, yeah, it's a contract of adhesion, Bruce. They'd sign anything that they put in front of them. They don't have a choice.
Contract.
It's a contract, fine. We think that choice has to be the option. And remember something, too. Registered investment advisors, I'd never had a case against an RIA up until probably 6 or 7 years ago. Now I've probably had 100. RIAs put AAA clauses or JAMS clauses in there. I've done a couple JAMS cases, single arbitrator, 3 days. The bill that I have to pay, or my customer, but I have to pay prior to the award coming out, $25,000. Look, we need arbitration. Because if you don't have arbitration, it makes it almost impossible for a client with $25,000 or $50,000 in losses to move forward with a claim. All right, but my position is FINRA isn't as cheap as what what FINRA executives make it sound. AAA and JAMS is extraordinarily expensive. You still need arbitration, but open the doors. Give customers choice, Bruce. How could you disagree with that?
Because it's incredibly inequitable for one party to have a choice of forum depending on the facts of their case.
So it's fair for brokerage firms to force us into arbitration.
Well, first of all, Mr. Gazillionaire, I wouldn't be complaining about the FINRA arbitration system too badly. You guys do very well. You guys win a lot of cases. You guys get a lot of settlements.
39% win rate last year.
Well, that's a different topic. That's because we settle all the good cases for you guys, which puts more money into investors' pockets. But here's the problem. You can't allow a party to wait for the facts of their case to develop to decide which forum to take. I don't have a problem with giving, and this is me speaking personally, I don't have a problem with giving a client a choice, but they have to make that choice up front.
Why not at the time?
Their customer agreement, they choose whether to opt out of the arbitration agreement. And if they do, that means it's going to court.
Why not after the time that the claim accrues?
Why do courts discourage the ability to forum shop by law?
Well, I'll tell you why, Bruce.
It's unfair to the defendant.
Okay,
That's
Bruce,
why.
I'll tell you the flip side of that argument. What if, and Alan, you're going to love this too, what if PIABA had an arbitration forum and PIABA promised that it would be fair and that we would have top-flight fair arbitrators that give everybody a fair shake, including the brokerage firms, Bruce? Would you say, gee, on behalf of my clients, that sounds like a wonderful idea. Let's go to that forum.
If after 40 years of experience I saw that forum was truly fair, and if anything, bent over to help the other side, like FINRA, it's mind-boggling to me that the plaintiff's bar continues to contend that FINRA is not a fair forum because us on the defense bar say the same thing. We think they bend over backwards to assist the claimants all the time, which, you know what that means, probably? It's perfectly fair.
I would suggest that you Google the concept repeat player bias. I keep track of hundreds, if not probably over 1,000 arbitrators in my database. There are arbitrators that I know with absolute certainty aren't going to give money, or if they do, their average award to claimants is less than 5 cents on the dollar with no liability again and again and again. The concept of repeat player bias is horrific. Google arbitration clauses and credit card companies and see what the win rate is for investors taken to an extreme when you're talking about thousands of cases. At a minimum, there's a perception that an SRO, a self-regulatory organization, can't be fair when you have the members in effect financing that arbitration form. Now that being said, do I mind arbitration? I like arbitration. It's just there's a problem sometimes if it's sponsored by the same firms that you're suing. Give investors a choice. I'd still file overwhelmingly at least half of my claims in arbitration.
That's the same regulator, though, that fines the street hundreds of millions of dollars every year. It's the same exact regulator. If they were in our pocket, they would be much easier to deal with from an enforcement perspective.
Google the term regulatory capture. A lot of these lawyers from the SEC and FINRA end up working for the same banks and brokerage firms that they're supposed to regulate. Do they go hard on them? I don't think they do. I think they get a slap on the wrist.
I don't know. They seem to go hard on my clients pretty regularly. But I could also pull out my arbitrator list, historical rankings list, and find arbitrators who always give money to claimants and always award interest and attorney's fees.
Could you give
That's
me those
why
names?
it's a good thing. That's why it's a good thing we have list selection, which gives us a choice of 30 arbitrators.
Tanya? Mr. Glick?
Just for
Please.
perspective, I've been on so many panels. I really can't think of more than one or two. Right, and I'm usually the chair. I'm always the chair now. I can't think of more than one or two out of like 100 that I felt somebody was prejudiced. I mean, the panelists, and they vary in intelligence, knowledge of the law. Some are not lawyers, and some are industry people who are hugely valuable in educating those who are not from the industry about what all those lists and names and numbers mean. But I can't think of more than a couple where I felt this guy or this lady is prejudiced one way or another. I mean, I think they take very, very seriously their oath, very seriously their disclosures. And when they say, they have that disclosure thing to fill out, which includes, have you decided, do you have any feelings one way or the other? And you're right, no, I haven't seen more than one or two who I felt were fibbing a little bit when they said that.
Thank you, Mr. Glick. Tanya, I think you wanted to say something?
Yeah, so I've been around for a really long time too. Talked to a lot of investors. I understand many of them. Nobody really knows what they're signing on to when they're presented a document and says you agree to go to arbitration. I do agree with you, sir, that I think most arbitrators are trying to do the right thing. There's just a lack of training, and the arbitrator pool should be expanded, but there's a little bit of a difference between going to court where you have people who are plumbers and teachers and everybody else. There's a judge. There's always a judge who says you can't put this in, who hears motions in limine in advance, who understands what the law is and ensures that the law is applied, which we don't have in arbitration. And that's one of the reasons I think individuals should have a choice, because even if your judge and jury makes a mistake, there are levels of review, which you don't have with arbitration. I will say this, the firms almost always are in a much better position, and I'm not talking about people who have institutional accounts at Goldman Sachs. I'm talking about the retail investor. The firms, Merrill Lynch will always have more money. They can go to any forum and out-litigate and outspend the investor, who's probably lost all his money, so they're already limited in what they have. I really think the attraction of arbitration for the firms is the sort of the confidentiality aspect. Because let's take a variable annuity. If somebody's suing a particular firm for some really terrible product that they're selling VA or private use, whatever, and it goes to court and they win, you have precedent and you have publicity and you have the opportunity to use that award as collateral estoppel for every other investor who was in that similar situation, which you don't have in the arbitration forum. So I think that that's really the real issue for the firms.
Tanya, you have once again demonstrated the wisdom of King Solomon. We are wrapping up. I just want the record to reflect that Jim Nix is wearing an Aaron Rodgers jersey at today's presentation.